Perhaps what is most important to remember regarding alternatives to guardianship of adults is that nearly all of the options exist when the individual still has decisional capacity and can make arrangements in preparation for possible future mental incapacity. Inability to make or communicate decisions can be a sudden and temporary situation, such as brain injury, or it can be a long-lasting condition, such as dementia or Alzheimer's disease. This video also discusses a few limited options in the event the individual you are assisting is already incapacitated and cannot make or communicate decisions for their own well-being. We hope this video will encourage you to make such arrangements and to review your arrangements perhaps every year to make sure they remain current. At a minimum, you should review it at least with significant changes in your life and upon diagnosis of a major medical condition. You can also rescind or change anything at any time to meet your changing needs and choices. We strongly encourage reviewing this video with your adult family members and trusted friends. Preparations are as important for younger individuals as it is for the elderly. This video discusses options available under New Mexico state law, and choices should be made consistent with the individual's beliefs, customs, traditions, and culture. For example, this may involve advance directives and end-of-life decisions which may or may not be consistent with traditional beliefs. Please note, this video is entirely focused on adults age 18 and older. You should know that guardianship removes considerable rights, and it should only be considered after alternatives have proven ineffective or unavailable. It is also important to remember that everyone is presumed to have capacity unless legally determined by a court to be incapacitated. This is a legal determination of functional capacity rather than a medical determination. Incapacity is defined differently for different purposes, and you must apply it only for the purpose intended. Rights that may be removed by a guardianship include decisions regarding your living arrangements, including involuntarily moving you, routine finances, arranging for other services you may need, health and medical, including protection from physical injury, illness, or disease, and withholding or withdrawing medical treatment, signing contracts, leases, driver's license, etc., clothing, recreation, education, training, spiritual activities, etc. The following are rights that are not removed by a guardianship. You retain the right to be represented by an attorney, make or change a will or trust, marry, vote, whether to practice religion and what religion to practice, request the court to terminate or change the guardianship and conservatorship. There's a basic difference of guardianship versus conservatorship. Guardianship for the person is called a guardian. Guardianship for the estate is called a conservator. Guardian for the person may also include routine financial matters. An individual may need both. A guardian appointed by the court has these roles: being an advocate for the protected person, protect their rights from infringement by others, seek, coordinate, and monitor services to provide for their support, care, comfort, and health. Making decisions for the protected person. This video is in the following 4 basic parts. Part 1, Introduction and Overview, including matters related to education and related to mental health treatment guardians. Part 2, Health, Medical. Part 3, Financial. And Part 4, Benefits, Services, and Resources. Please note this video has the option for Spanish or English captions. Decisional capacity is required for all aspects of our life. For example, where we will reside, finances, other services and support we may need. Medical includes protection from physical injury, illness, or disease, signing contracts, leases, etc., protecting ourselves from undue influence, exploitation, or fraud. Such decisions require what is typically referred to as informed consent, which is the agreement to allow something to happen, and this requires being competent, being mentally and physically capable of understanding the nature of one's acts, and making, communicating, and acting on one's own decisions. Being informed, the individual understands the nature of the decision involved, benefits, risks, and drawbacks, availability of alternatives including no treatment, and the risks and benefits. Decision being voluntary, the individual freely decides whether the risks are worth the benefits and expresses an opinion. It is best that we make preparations in advance for us to always have a say in decisions about our well-being. Although we may not think about it in this way, our decisions normally involve what we believe to be in our best interest, along with our wishes and desires based on our values and our experiences. Our best interest usually refers to relief of suffering, restoration of functioning, normalization, quality of life, opportunity for future satisfaction, possibility of future regaining of self-determination. Our wishes and desires are usually woven into our decisions and involve our preferences. Should we lose our ability, even temporarily, to make or communicate decisions for our own well-being, it may be very difficult for someone else to make those decisions for us. Someone else is likely to make decisions for us based on what they believe to be our best interests without knowing our preferences. The term substituted judgment is commonly used, but it should not be confused to mean that someone else is substituting their judgment for that of the incapacitated person. It simply means the decision maker is trying to make the decision the incapacitated person would have made for themselves. Substituted judgment should be used prior to deciding based on what we believe to be the individual's best interest. There are various ways to document a person's wishes, such as the values history, 5 wishes, and others. Resource material is available for these on the Internet. This is why guardianship should be as a last resort and only as necessary to promote and protect the well-being of the individual and others. Guardianship should include the least restrictive means necessary, and the preference is for a limited level of guardianship rather than full plenary guardianship. If you are trying to help someone who is already incapacitated, guardianship may very well be appropriate to protect the person's health or safety. Please view the separate guardianship video that is also available from the websites of the Office of Guardianship or the New Mexico Guardianship Association. Guardianship is not for those who make bad decisions, but there must be a determination by the court that the individual is incapacitated, which means partial or complete functional impairment, making them unable to manage their personal affairs due to mental illness, mental deficiency, physical illness or disability, chronic use of drugs, chronic intoxication, or other cause. Courts should only remove those individual rights that the proposed protected person is incapable of handling. Guardianship may involve seniors with a disability, dementia, Alzheimer's disease, individuals with a developmental disability, over age 18, including students where the schools encourage guardianship, individuals with a traumatic brain injury, adults with mental illness, mental health treatment guardians, adult protective service cases involving substantiated abuse, neglect, including self-neglect, and exploitation. Individuals susceptible to fraud or undue influence. For additional information related to guardianship, please see Video and Handbook for Guardians and Conservators, Office of Guardianship website, National Guardianship Association Model of Ethics and Standards of Practice. If the need is only related to mental health treatment and medication, there is a unique type of advance directive you may prepare, and you can designate in advance who you would want to make such decisions for you. There is also a unique type of guardianship called the Mental Health Treatment Guardian. For more information regarding mental health treatment guardians, please contact the National Alliance for Mental Illness, NAMI, of New Mexico at 800-953-6745. Additionally, the facility and/or professional may be able to help. A mental health treatment guardian can seek an enforcement order from the court for the forcible administration of medication if the client refuses to comply. Please review the other parts of this video which discuss alternatives, mostly while capable, including power of attorney, representative payee, informal arrangements with family members, advance directives, advance health care directive, and mental health directives, etc. Surrogate or substitute decision maker for medical health care decisions, You may designate an individual to act as surrogate by personally informing the healthcare provider. If none designated or available, then a family member or someone familiar with the patient's personal values may make decisions for the incapacitated person only for medical health care. If no agreement, then majority of that class, or if the class is evenly divided, then the class and all with lower priority are disqualified.